All right, and moving forward, I have a warranty deed with vendor's lien. This is a very modern document. This is how all of the modern documents are styled. And what's new about this one is that we have a vendor's lien. Vendor's lien means that there is a mortgage and a deed of trust associated with this document. So you would definitely want to go and get a copy of the recorded deed of trust that matches this, which I actually have here. Just pull that up. While I'm at it, is it opening? All right, before we get to that, you'll notice here that the consideration is $10 again. We won't know the total amount that was paid for this piece of property and don't need to know, but what we do know is that there was a note. This is what we generally call our mortgage. A note of this signed this same date in the principal amount of $88,000. It was executed by the grantee or the buyer, payable to the order of Texas National Bank of Jacksonville. So we don't put mortgages of record at the clerk's office. Mortgage is a paper that's not public. It's a set of paperwork. It's not public. What we put public that memorializes the mortgage is called a deed of trust. And that's what's recorded simultaneously with a warranty deed with vendor's lien. There's always a matching deed of trust to go with it, and this is the matching deed of trust. You can see this is volume 2290, page 36. This was volume 2290, page 30. So the exact next document, which is exactly how they're supposed to be recorded, is the deed of trust. You have the same grantor. The grantor in the deed of trust is the grantee of the warranty deed with vendor's lien. So a deed of trust is what gives the beneficiary, in this case it's the Texas National Bank, the authority to repossess the property. It's literally a deed. This document is a deed, and it's held in trust. The trustee is Royce Fletcher. And if the Stovers, in this case, were to not pay their mortgage, Royce Fletcher would convey this property to Texas National Bank. This document gives him the authority to repossess the property and to sell it to Texas National Bank, who's the beneficiary of all of this language here, which we don't really examine all that much. What we want to make sure is it's the same property. Here it's 34.74 acres. Let me go back to the warranty deed with vendor's lien and see the property. All that certain lot, tract, or parcel land being 34.74 acres. So it's the same property. You can look at the Exhibit B and look at the meets and bounds. It's back here. Whoops, back here. All that certain tract or parcel land being 34.74 acres, more or less. And it's the same legal description as on the exhibit, on the deed of trust. So I'm going to back up here because there's something else in this warranty deed. And it's a list of easements and exceptions to conveyance. And really, you have this a lot in documents. Some documents have none. There's certainly not a rule that you have to have these things. But the more and more modern a document is, and if it closed through a title company, which in this deed you can see that it did. You see this area down here. CTC means Cherokee Title Company, and this is the guarantee file number, and it's the Wilcox to Stover deed. So generally a title company will have some sort of identifier down here, and when you have that, you know that they're going to have exceptions to conveyance and warranty. And when we see these things listed, we also need to add them to our title. So here's a right-of-way filed in this volume and page. We would get that. We would get this one, and this one, and this one, and so on. So that the buyer can be aware of all of those easements that are coming across the property. I started to highlight this one, but we don't We don't do oil and gas at all, unless it's specifically requested by the lender. In most cases, that doesn't happen. So we wouldn't get this, and we wouldn't have it on our document. And we get this right away. And we'd also note this. It says all those matters together with all rights incident thereto shown on the plat of survey prepared by J. David Berry, and so on. We don't have access to this survey, but we do know that it exists, probably can be retrieved if necessary. So the buyer could get that. They would probably have to pay the surveyor for a copy of it if they weren't getting their own survey. And so these would become all part of our title. And this is the setup of a warranty deed with vendor's lien. And if there's a deed of trust on a piece of property, we're going to look to see if it ever got released. Because if it's not released, meaning it's not paid off, then we're going to have to require the seller to pay off that deed of trust at closing. And essentially what we do as a title company is we pay off these liens. We get the payoff amount, and then we will wire the money to in this case, Texas National Bank, Jacksonville, and make sure that this note is paid off. We will send Texas National Bank a release to sign so that we can record that, and that way we've made sure that once this deal is done, that everybody that's owed money gets their payment, and all the liens and judgments or deeds of trust that might be in the record are paid off and releases are filed. So we want to make sure that the buyer gets clean title and free from any adverse claims whatsoever.